Welcome to Law Talk with Peter Meyer.
Hi, everybody. Welcome to episode 3 of Law Talk with Peter Meyer. I'm Matt Skye. Peter provides personalized and professional representation for personal injury and wrongful death cases across Georgia, empowering injured individuals to recover financially and hold those responsible accountable. Peter, thanks for joining us.
Hi, Matt. Great to be with you.
So, Peter, let's jump in. Can you explain for us what premises liability entails and who might be liable in cases involving injuries on someone's property?
Well, premises liability cases are a type of tort, a type of injury case or wrongful death case, which is very different than a car accident, for example. We're basically talking about a situation where the owner or person in possession of, say, a business or a home has somebody injured on their property. And I get calls all the time for the last 25 years where somebody's hurt on a business, say, and people assume that they're automatically responsible if you're hurt on their premises. But it doesn't really work that way. There's extra layers of protection in the law that the owner or business owner has. Basically, the property owner or business, they have a legal duty to keep the premises reasonably safe of hazards for what the law calls invitees. It's basically just customers, anybody that you allow onto your property, like a customer in a store. And these hazards, I feel like I've seen just when I think I've seen everything, something else comes along. But commonly it can be a slippery floor from a leak or a leaking cooler or a leaking roof, just about everything. Falling merchandise in some of these stores like Home Depot, you've seen horrific injuries.
That sounds terrifying.
And it can also be a construction defect or a dangerous condition on the premises or a walkway that for the owner to be responsible, in a nutshell, they have to be able to it has to be foreseeable that somebody could be injured due to that hazard. There's several cases. Another type is inadequate security. You can have a terrible crime committed, say, at a motel or a hotel, and you say, well, they're not responsible. The criminal came there. But if they could have had just the minimal adequate security to prevent it, they can be responsible for that. Those cases are another type of premises case. But people just need to understand that they're not responsible just because you're injured. We have to show that the employees, the managers, the owners either actually knew about the hazard and failed to correct it, or they should have known about it through the exercise of ordinary care. That's called constructive notice.
So you touched on this a bit, but can you lay out for us the common types of accidents or injuries that fall under premises liability and then how they differ from personal injury?
What's most common is your slip and fall or your trip and fall. There's something on the floor, whether it leaked from the roof or a product or a cooler, or was placed there or dropped there and somebody falls and gets injured. And then you have what they call static defects. There may be a step or a walkway or some other thing, and I've just about seen it all, that is not up to building code. It's an open and obvious hazard, and somebody can be seriously hurt with that. And so these differ from a car accident in a lot of ways. The most glaring thing and the reason why a lot of lawyers don't like these cases and refer them to me is a car accident happens out in the public, right? It's in the roadway. You've got witnesses, you've got other drivers, the police officer comes out and examines the scene, writes up a report, about what happened. But on a premises case, the witnesses are all pretty much at the scene. Most of them are employees of the defendant. They don't want to lose their jobs. The store, they own the building. They own the video cameras. Gathering evidence in a case like that can be more of a challenge than a car accident, where you can talk to the officer who came to the scene or go to the roadway and take pictures. So there's certain steps that we have to do in a premises case that are different than what we have to do in another type of injury case.
And how do you get that evidence? Because like you're saying, I can imagine it's extraordinarily difficult in certain cases.
It is. And you do run into a lot of companies that are hiding the ball, a lot of employees that they're just afraid of losing their jobs. So they don't want to admit that they did something that caused my client to have surgery. So the first thing we do is we'll send what's called a spoliation of evidence letter to the store and their insurers. That basically lists a whole page of things: video surveillance and employment records of prior incidents there, any cleanup or maintenance procedures, their policies and procedures of the company. We request that they save all of that And so they can send it to us when they're required by law to send it to us. And then also, of course, we'll go out to the scene, and kind of undercover, do a little detective work, take my tie off and, take pictures. I tell my client, when this happens to, if it happens to somebody and you're calling me right from the scene, just take a few pictures. But because keep in mind, Matt, we have to show not only, that they knew about it or should have known about it. We also have to show that this is not a condition where the injured person could have easily seen or avoided it. That's an extra burden that we have. That we'll get into that in a minute, but that's an extra layer of protection that the law gives to the property owner. And I'm happy to elaborate on that if you'd like.
Definitely. But Peter, to just first ask you, what are the responsibilities of property managers in terms of keeping their property safe?
The short answer is that, I own this office building, or we go to Kroger, or any other store. They have an absolute legal duty to keep the premises free of hazards that would injure a customer coming into the building. So that sounds pretty self-explanatory, but it can get complicated. For example, I've had cases where there's water on the floor, whether it's from a customer spilling it or leaking from a cooler. If, let's say, something leaks on the floor and then 2 seconds later a person falls in it, the store is not responsible because they had no time to see it and clean it up. Unless it was like, I've had cases where the roof was leaking and they've repeatedly refused to fix it. That's different. But if there's something like a spilled in the grocery store, we have to show that it was there long enough. And so that frequently has to do with the other footprints through the spill. And this is where photographs and video come into play. Or a lot of places have a log of exactly when they do the cleanup, or a policy when they're supposed to do the cleanup. And this is where you really get into the weeds, but, it all ties into the fact that the owner has a duty to keep that place free of hazards that they could foresee that would injure a customer. And I want to point out something incredibly important from the injured person's point of view. We have to show that they were not aware of the hazard or didn't have what's called superior knowledge of the hazard. So like if you are walking down an aisle of a store and there's a big massive puddle and you choose to walk through it, you had equal knowledge to the property owner. You're not going to recover. That case would be thrown out on summary judgment. A lot of cases have gone through, and this is one of the most litigated areas in the appellate courts and the Supreme Court over the last 26 years that I've been doing this. And many cases have been thrown out on what's called summary judgment before it even makes it to trial, because they have ruled that the customer had equal knowledge of the hazard. Therefore, the store owner was not responsible. Does that make sense?
Yeah, so it seems like you have to be aware. I mean, when you go to a grocery store, for instance, if there's a spill, you put up a wet floor sign, or there's a certain expediency we expect. So the idea is, I guess, the customer has to have a reasonable, or not customer in this case, but whoever is liable has to have a sense of what the risks are.
Yeah, and so what we have to prove from our end is either we can prove where it came from and how long it was there, which is not always so easy to do, or prove that they had actual knowledge. I've had cases where water was coming in the front door and, I got through discovery and depositions, a manager had said, I told them to put signs up. I told them to put mats out, and they didn't. That's actual knowledge. The constructive knowledge is proving that it was there for a long time, or that the hazard was in full view. Like, say, I've had situations where there's a hazard right by the registers and you've got half a dozen or more employees right there staring at it all day long. That case will win and not get thrown out of court on summary judgment motion because it was in clear view of multiple employees. So the court will say they had actual notice. I have so many examples I could give of that, but they basically have to either clean it up, put up a sign, or, fix the hazard. That's talking about a spill. If it's a fixed hazard, the same rules apply. If they know about it or should have known about it and somebody's hurt, then they can be held liable.
I can totally understand why some people prefer the more automotive cases, because I can see a million variables at play. You're definitely taking that tie off a lot in being a detective. But it's so true. If I could interrupt for a second, I just had a case just recently. This fella came to me, super nice guy, like a lot of slip and falls. He tore his rotator cuff and, had some back injuries as soon as he walked in the store. And this case was literally turned down, by 10 other firms. And, he came to me and he wasn't expecting much. He says, I've been turned down by 10 firms. So I listened to his story. And the reason he was turned down was because he told the other lawyers, oh, yeah, it had been raining. I walked in the store and I fell. And the courts have said,
if it's raining and you walk in, you should know that the floor is going to be wet. So, but he said, but it hadn't been raining for hours. They have this whole big area that I walked through before I got in the store where it's supposed to dry your feet. And I heard a manager say, I told them to put mats down and cones and clean this up. This is what he told me. So I knew we had enough to overcome summary judgment. And to just make a long story short, 10 lawyers turned him down. I knew the elements were there to win the case. There was still a chance we were going to lose, but I felt confident in it from doing this for so long. Case had been flat out denied from the insurance company from day one, and they tried to have it thrown out. We made a really strong argument. The judge agreed with us, and we won that client a six-figure, it's a confidentiality agreement, but we won him a multiple six-figure award on a case that 10 lawyers had turned down because we proved, you have to get in the weeds and do the work. And that's what we did in that case. And we try to do in every case.
Can we jump a little bit into the concept of duty of care and what that means?
Well, the duty of care really is that the duty that is put upon the premises owner or manager of the property to keep it reasonably safe for foreseeable hazards. And, we've talked a lot about like substances on the floor that, have to show that it was long enough for it to be cleaned up. They should have put up signs. But what's not even more common, but what also happens is we have what's called a static defect. It's a construction defect or something. I've had stairs that were not designed properly. It can be a violation of a building code or a safety code or just an obvious hazard, a hole. I've had cases with a gaping hole in the parking lot. It's foreseeable that somebody can be hurt in a situation like that. And those, what they call static defect cases, are even more challenging in the sense that the court says, wait, your client, or any person walking in the store could have easily seen that. So you still have to overcome that burden of the injured person having equal knowledge. But that's not always the case. So, I had a case in Milledgeville that had a walkway that was right outside the door where you came in and out of the store. So my client came in the other door. He was walking out with this giant box. It was a large hardware store. I can't say which one. We signed non-disclosures. But as he's walking out, his foot steps off into this big hole where I think it was supposed to be a planter at one point. It was just a gaping hole right off the side. He had pretty serious injuries. He was an older man. The insurance company said that's open and obvious. He could, easily have seen it. So our experts showed the numerous safety code and building code violations that it had. Plus, he couldn't see it because literally as soon as he walked out the door, it happened. And they argued pre-existing conditions and all that nonsense. But he was turned down by several law firms. We did all the hard work, and I think we got him just shy of $500,000 in that case.
So if someone is injured on another person's property, what are the immediate actions they should take?
Well, report it right away to an employee or somebody who works there. You want to get it documented that it happened. Request the internal incident report. Most places have a policy where they will not release that, but sometimes they will. Sometimes an employee doesn't know they're not supposed to, just so we can prove that it was reported to them. If possible, take pictures of the area and ideally of the hazard that caused the injury. Because if it's substance on the floor, it's going to be gone. And then you come hire me and you're telling me something happened, but I can't see it. I can't photograph it. So if you can, and I've had this happen and it made the case, take a picture. We had a case where, the spill had been there for a while and you could tell because there were just footprints tracked through it. And then you could see exactly where my client fell. And so, they tried to say that, oh, this just happened, but clearly it was right in front of a bunch of employees and people have been traipsing in and out of it. And that was another situation where one of the employees, when we talked to them, said, I told them to clean that up. I told them to put out signs. So take pictures, get the names of witnesses if you can. And any employee you talk to, try to get their name as well, because we're getting involved later on and we're going to want to talk to them. We cannot speak to them unless we depose them while they're still working for the company. If they're a former employee, we can talk to them and we get a lot of good information because my client will say, I know so-and-so worked there. And like any injury case, get medical treatment without delay and call a law firm that specializes in these premises cases so we can do the groundwork before the evidence disappears. And in premises cases, it always disappears.
Yeah, it sounds oddly kind of similar to automotive cases in a sense, just like document, have that phone camera ready and on. Am I right?
Oh, yeah. It's so true. It's more challenging for us because a lot of times they'll hire us months or a year or more after it happened. And then, we're completely reliant on what the defendant in good faith has provided us in response to our requests that they preserve and provide evidence. So it's really, if it happens to you, try to find out who saw it, get the names of everybody, report it to the store, and get pictures if you can. We have won so many premises cases based on photographs either my client took or me and my investigators took. I'm thinking of like a roof leak case. In that case, I think we had to sue so many parties because everybody was pointing fingers at each other, but it was clear that this had been going on for a long time because there was so much water damage in the ceiling and on the floor where it leaked in multiple spots. And like right after they hired us, they went in and renovated the whole store. So if we hadn't gone in and gotten those photographs, we wouldn't have been able to, to show the extent of how bad shape this was. And that's common sense, back to that duty. You wouldn't let somebody in your house if water's leaking all over the place. You can't let them in your business. It's dangerous. And that's why they're held responsible.
What kind of statutes do you work with? Are there any kind of limitations?
Yeah, the statute of limitations in Georgia is 2 years, meaning from 2 years from the date of the accident, you have to either settle the case or file a lawsuit and serve the defendant within that 2-year period. And that's why it's important to hire a law firm that is a specialist in premises liability cases right away, because we have to do so much work behind the scenes before we even present the case. And if you come to me a year and a half after it happened, I may not have the time to do what needs to be done to win that case. So at least get a consultation right away.
I think we covered this already, but let's just do kind of a zoom out and a final takeaway. What's your advice for people who have had a liability claim? How can they best navigate the legal process? And how can they seek compensation for those injuries?
Especially in a premises case, document the scene, document the hazard, get the names of the witnesses and employees, report the incident right away to the store, get a copy of that incident report if they'll allow you. And the most important thing is get in touch as soon as possible for a free consultation with a specialist in premises liability cases, because hopefully some of the examples I've discussed today illustrate how we have to do so much groundwork to prove and win these cases, and they can be even tougher than accident cases. And that's why we get referrals from lawyers all over the state who say, hey, take this premises case. I don't want to deal with it. And there's a lot of work to be done. So give me a call as soon as possible and let us evaluate the case as soon as possible.
Well, it's fantastic. It sounds like you're taking on the tough cases that others might not want to. Thanks so much for tuning in to Law Talk. For more information and to connect with Peter Meyer, visit meyerlawfirm.net. You can also find him on social media. Peter, thanks so much for your time today.
Thank you, Matt. I appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.